CR delay here. I'll call court to order in just a second. Oh yay, oh yay, oh yay. The Honorable Supreme Court of Arkansas is now in session. All persons having business before this honorable court, draw near, give attention, and ye shall be heard. May God save these United States, the state of Arkansas, and this honorable court.
Oh, good morning. This is the court's first proceeding of the new year, and we want to welcome our newest colleague, Justice Barbara Webb. Welcome, Justice Webb. We regret that we've not been able to hold your formal investiture ceremony due to the restrictions of the pandemic. When it's safer to hold an in-person ceremony, the court will announce the date for that investiture. Will the clerk please read the submissions?
There are 6 appeals being submitted to the court for decision today, the first of which will be our oral argument. It is criminal case 19-762, Randy William Gay versus the state of Arkansas, an appeal from Garland Circuit. We also have criminal case 19-684, Bobby Kellensworth versus the state from Grant Circuit. Civil case 20-50, Rent-A-Center East Inc. versus Larry Walter as director of the Department of Finance and Administration, which is an appeal from Pulaski Circuit. Civil case 20-211, Cherokee Nation Businesses, LLC versus Gulfside Casino Partnership and others, an appeal from Pulaski Circuit. Civil case 20-216, Convent Corporation versus the City of North Little Rock and others, also from Pulaski Circuit. And finally, civil case 20-425, Leslie Rutledge, the Arkansas Attorney General versus JMS Enterprises and others from Searcy Circuit Court. In addition to those 6 appeals also being submitted to the court this morning are 12 other various motions and petitions, all of which are available on the court's website.
Okay, thank you. Our case for oral argument today is Gay v. State, CR-19-762. Justice Rhonda Wood has recused from this case. Tim Snively has been appointed to serve as special justice. So welcome, Special Justice Snively, to this case.
Thank you.
And the court will now recognize the appellant for his argument. Mr. Hendricks.
Thank you, Mr. Chief Justice, members of the court. If it pleases the court, I'm Blake Hendricks. I represent the appellant, Randy Gay, in this case. This is an appeal from the denial of post-conviction relief in a death case. The issues principally involve the adequacy of jury selection in a capital case and trial counsel's duty to conduct a reasonable investigation into mitigating evidence. The facts are, of course, contained in the direct appeal opinion at Gay v. State. Essentially, Gay lived off the grid in the Ouachita National Forest and served as a night watchman for a logging company there. On May 10th, 2011, Gay arrived at that logging site with Connie Snow as his passenger in his pickup truck. Gay told the loggers that he was taking Snow to jail. There was a verbal confrontation between Snow and Gay. Gay ordered Snow out of his truck. As she exited, she said, "What are you going to do? Shoot me." Gay did, in fact, shoot her in the face with a shotgun. He then put her body in the back of his pickup truck, drove the body about a mile away from the crime scene, and disposed of her body there. Her decomposed body was found about 4 days later. The first case was tried in April of 2013. Gay was represented by private counsel at the time. That case resulted in a mistrial because of juror misconduct. The second trial was held in March 2015. The public defender of Garland County was representing Gay at the time. Gay was convicted of capital murder, and the case then proceeded to the sentencing phase of the trial. The state presented 3 aggravating factors: the convictions for 2 homicide convictions, one of Gay's father-in-law from 78, I believe, the second homicide conviction of his father. There was a third aggravating factor, a terroristic threatening conviction. The mitigation case put on by the defense consisted of 6 witnesses. There were general character witnesses. Gay's sister testified to essentially the history of his background, and an ADC employee introduced Gay's prior ADC records, familiarly called as pen pack. After the conviction and my subsequent appointment as Rule 37 counsel, we held a Rule 37 hearing in which we presented the testimony of 3 expert witnesses. We had Professor Tom Sullivan to act as a so-called Strickland expert to help explain the standards of care for capital counsel and defense counsel in capital cases. And then we presented the expert testimony of Drs. Matt Mendel and Dr. Roach, both who were experts in the field of child abuse trauma, chronic alcoholism, and pharmacology. The state introduced the testimony of trial counsel and of the trial mitigation specialist. Now, turning to our claims, Justices, I believe I can easily and efficiently dispose of one claim for us this morning. We claimed in the petition and on appeal that 2 of the jurors that were seated on Gay's jury, Barker and Weddington, those were 2 jurors who stated they would automatically vote for the death penalty on a capital murder conviction. The trial court overruled Gay's challenges for cause to those 2 jurors. We cited this as error, but the defense struck those 2 witnesses using their peremptory challenges. The state has cited this court's opinion in Willis versus State, which in turn cites Ross versus Oklahoma, a 5-4 decision from the United States Supreme Court, I think from '88. And the state is correct on that, because what Willis, relying on Ross, held was it's essentially harmless error, that if 2 unqualified jurors are simply not paneled and the defense has to use their peremptory strikes, it's essentially harmless error. So the only way that I can gain relief, Justices, on that claim is, 1, by, if I have to ultimately go into the United States Supreme Court on certiorari review and asking them to overrule it. Of course, this court can't overrule Ross versus Oklahoma. The only relief I could get is if this court found fit to overrule Willis based on the state constitution. So that, I think, disposes of that issue. The jury selection issues in this case. None of the jurors or none of the members of the panel were ever asked during the voir dire if they could give meaningful consideration and effect to any type of mitigating evidence, particularly mitigating evidence that was relevant to this case. We raised this as a freestanding, fair and impartial jury claim in argument 1 of our brief, and as an ineffective assistance of counsel claim that's raised in our brief, the argument 2A. Justices, the case central to capital voir dire is Morgan versus Illinois. And Morgan begins with 3 fundamental propositions. First, to be qualified to sit on a capital jury, a person must be able to give meaningful consideration and effect to relevant mitigating evidence. 2, a component of the right to a fair and impartial jury is the right to an adequate voir dire to identify unqualified jurors. And 3, general questions of fairness and impartiality, in other words, will you follow the law questions, are constitutionally insufficient to qualify a person to sit on a capital jury. Now, in my reading of Morgan, the consistent theme throughout Morgan is that a constitutionally fair and impartial capital jury can only be achieved through specific enough questioning to determine who can give meaningful consideration and effect to relevant mitigating circumstances. The quote from Morgan, as with any other trial situation where an adversary wishes to exclude a juror because of his bias, it is the adversary seeking exclusion that must demonstrate through questioning that the potential juror lacks impartiality. And that quote in Morgan and the phrase through questioning is highlighted in the opinion itself, emphasizing the need to be able to adequately question jurors regarding their views of mitigation evidence. Now, trial judges, of course, are granted broad discretion in conducting voir dire, but that discretion is bounded by constitutional notions of fundamental fairness. So Morgan cites Ham versus South Carolina as an example of the constitutionally bounded discretion of trial judges in conducting voir dire. In that case, an African-American was on trial in South Carolina on a drug offense. His defense was that the prosecution was racially motivated. He asked the trial court to inquire of the jury panel their views to determine whether there was racial animus on the potential juror members. The trial judge refused to do that. The Supreme Court held that that was error, that the trial judge had abused his discretion, and that line of questioning was constitutionally required, that it was constitutionally required to be able to question and dig into that specific concern. To paraphrase Morgan, without the ability to do that, the specific concern was left unprobed. Now, in this case, the specific question was the juror's ability to give meaningful consideration and effect to relevant mitigating evidence. And that specific concern, like in Ham, was left unprobed. Only the most general type of mitigation questions were asked. For instance, the panel was asked, can you consider mitigating evidence? Now, of course, I submit that that's a meaningless question. You need to then define what is mitigating evidence. And attempts were made to try to define it, but here were the definitions that were given. Quote, a mitigator is anything that you can consider for reasons not to give death. That's at the abstract at page 329. Another example, mitigating circumstances are reasons not to impose the death penalty or reasons to spare life. The final definition, mitigators can be whatever you want. My submission to the court is that much more is needed than that to impanel a fair and impartial juror in a capital case. When only asked, can you think of a reason to not impose the death penalty? A juror in good conscience could think, yes, if the defendant acted in self-defense. But self-defense is a justification to the homicide, not a classic mitigating factor for the mitigation phase of a death penalty case. Another quote from Morgan that helps, I think, explain that. The defendant on trial for his life must be permitted on voir dire to ascertain whether his prospective jurors function under such misconception. The risk that such jurors may have been impaneled in this case and infected petitioner's capital sentencing is unacceptable in light of the ease with which the risk could have been minimized. I suggest to your honors that the risk of impaneling a jury in Gay's case that could not give or could give meaningful consideration and effect to relevant mitigating evidence could have been easily avoided. It was simply the ability, the trial court allowing and the trial counsel asking the very simple questions relevant to this case. Can you give meaningful consideration and effect to child abuse trauma as a factor mitigating against the death penalty? Can you consider intoxication as a factor mitigating against the death penalty? And it's in that regard, that specific question about intoxication, that becomes additionally important in Gay's case. I'm referring now to the arguments 1D and 2A. Consistently throughout the jury selection process in Gay's second case, the state asked if a defendant's punishment should be less if he was intoxicated. Two of the jurors who said no, that intoxication cannot be a mitigating factor, were impaneled and sat on Gay's jury. Trial counsel did not object to the state's question about intoxication, and defense counsel did not move to challenge those two jurors for cause. Those jurors, justices, were unqualified to sit on Gay's capital jury. Intoxication is, of course, a mitigating factor. It's recognized as a mitigating factor under the Arkansas statute 54605. It's recognized in case law as a constitutionally permitted mitigating factor. But those two jurors unequivocally stated, we will not consider intoxication as a factor that would lessen one's punishment. And they sat on that jury and they were unqualified. Because they sat on that jury, Gay's right to that fair and impartial jury was violated. We argue that as a freestanding 14th Amendment claim, but it was also professional error in our estimation for trial counsel not to object to the question and his failure to challenge those two unqualified jurors for cause. Second part, of course, the Strickland analysis is prejudice. Was Gay prejudiced by trial counsel's failure to do that? And I suggest to the justices that prejudice is presumed in those circumstances. Morgan held, and to quote, if even one such juror is impaneled and the death sentence imposed, the state is disentitled to execute the sentence.
Mr. King,
Yes, sir.
let me ask you, irregardless of these two jurors' opinions on intoxication as a mitigating factor, the jury did not find that Gay was intoxicated in the first place, the other 10 jurors. So where's the prejudice?
Well, the prejudice is, Your Honor, that those were simply unqualified jurors, and ipso facto, he was deprived of a fair and impartial jury. At the beginning of his trial, the panel was infected by the presence of those two unqualified jurors. There is an issue raised in the state's brief of whether this is a claim that can be litigated in Rule 37 because it was addressed on direct appeal. And to make brief mention of that, the issue on direct appeal was a very broad. Gay was deprived of the right to a fair and impartial jury because of the inadequacy of voir dire. I suggest to the court that this precise issue, which again is a precise issue, the adequacy of voir dire by asking, can you give meaningful consideration and effect to relevant mitigating circumstances? That issue has not yet been litigated, and that's the issue we're here to litigate today. Second, regardless, we also raise it as an ineffective assistance of counsel claim, which is obviously something that was not addressed or litigated on direct. So in sum on this argument, I submit that Gay was deprived of a fair and impartial juror first, because Gay was not afforded an adequate voir dire to explore relevant mitigating evidence and whether jurors can give meaningful consideration and effect, as they must be under Morgan to be qualified to sit on a capital jury. And two, because two of those unqualified jurors actually sat on Gay's jury. I also submit that Gay was deprived of the ineffective assistance of counsel for counsel's failure to ask those questions. Can you give meaningful consideration and effect to relevant mitigating evidence? And by counsel's failure to object to those two unqualified jurors. An idea, a notion, Your Honors, that comes up in that jury selection issue was, well, why weren't those relevant mitigating questions asked? And there's some debate on it, and I think the record is sort of muddy on this. Was this trial counsel not knowing the standard of care for defense attorneys in capital cases? And as Professor Sullivan gave his opinion, it is the standard of care. It is our professional norm to ask whether jurors can give consideration to relevant circumstances that are relevant to the case. Or did the trial judge prohibit him? And the record is frankly muddy. If it were the trial judge that prohibited that line of questioning, then it was the trial judge that violated Gay's right to a fair and impartial jury. If it was trial counsel's failure to ask, then trial counsel failed to live up to the professional norms and Gay was prejudiced. It seems to me that if trial counsel knew his duty to ask those questions, but believed that the trial judge would forbid it, then trial counsel should have proffered those questions, and those questions should be in the record, and they're not. So that's why we propose this as both a freestanding 14th Amendment and a 6th Amendment ineffective assistance of counsel claim. Now, turning to what I think is the other principal, one of the other principal issues in our case, it's the ineffective assistance of counsel claim, and it's the failure of trial counsel, in our estimation, to conduct a reasonable voir dire. I see that I'm almost running out of time. To be concise, our post-conviction mitigation investigation, which was based on evidence known to trial counsel, revealed the existence of 2 expert witnesses, Drs. Mendel and Dr. Roach, both who were able to provide at the Rule 37 hearing what we believe to be very powerful mitigating evidence. And that simply was Mr. Gay suffers from mental issues that reduced his moral culpability and lessened the need for death in this case. All of that evidence was known to trial counsel, yet trial counsel failed to conduct a reasonable investigation to find the evidence that we found. I am out of time and only have a minute and a half for rebuttal. If there are no further questions at this stage, I'll conclude this part of my presentation.
Okay, thank you. Court now will recognize the appellee, Mr. Jackson.
Thank you, Mr. Chief Justice, members of this court. May it please the court, I'm Assistant Attorney General Adam Jackson, and I represent the state in this matter. On May 10th, 2011, appellant murdered Connie Snow in cold blood in front of multiple witnesses. Afterwards, he drug her body by her hair and belt loops to the back of his truck, hefted her up on his knee, then tossed her body in the back of the truck, then drove off. Her body was found 4 days later, about 1.5 miles from the logging site, in a shallow creek bed. The hair and the scalp had become detached and was laying some 20 feet away, and there was evidence that animals had gotten to her body. During the sentencing phase of trial, the jury learned that this was appellant's 3rd murder by means of shotgun to the face. He had been previously convicted of 2nd-degree murder of his father-in-law, James Kelly, in 1978, and his father, Glenn Gay, in 1991. In addition to that, the jury also heard that he had threatened a person who was employing him by the name of Mr. Ward. He threatened to kill him, and as such, he was convicted of first-degree terroristic threatening. It is unsurprising that, having heard about his prior violent felonies, that a Garland County jury gave the death sentence. Now, appellants raised a litany of issues in this Rule 37 proceeding, most of which could have been or should have been raised on direct appeal and weren't. And as such, they're not cognizable here. The one issue that is cognizable is the allegation of ineffective assistance of counsel. And as part of that allegation, he's pointed to 8 instances where he believes counsel was ineffective. I'm going to talk about 2 of those claims here today: the allegation that he was ineffective during voir dire and the allegation that he was ineffective investigating and presenting mitigation evidence. Counsel was not ineffective during jury selection. He claims appellant claims that he was ineffective in 2 ways. First, that he failed to ask these mitigation-specific questions of the jurors, and second, he claims that that counsel was ineffective for permitting Stacy and Fry to sit on the jury after they had said that they didn't consider intoxication to lessen the punishment. As to the first part of that, the failure to ask mitigation-specific questions, it's really not an issue of counsel failed to ask them. He attempted to ask these questions, early on. The circuit court said, that counsel, you're starting to argue the facts of your case. I'm not going to allow you to proceed down this path. And that was the end of it. Counsel Mark Frazier started to do this mitigation specific question and then just simply was prevented from doing it by the court. Counsel cannot be ineffective because he was prevented from doing something by the circuit court. As to the second part of the voir dire claim, his argument is premised on a fundamental misreading of Morgan. Morgan only stands for the proposition that a juror who would automatically impose the death penalty without consideration or regard to any and all mitigators could be or can be struck for cause. Morgan, as far as the state can tell, has never been extended in the way that appellant argues to say that one single mitigating factor and the inability to give weight to one single mitigating factor would impair or cause the juror to be biased. And furthermore, this is in the context of a Rule 37 proceeding where it must be conducted pursuant to Strickland analysis. And as such, counsel had a valid trial strategy here, and it was borne out in allowing these jurors to be seated. His stated trial strategy or voir dire strategy in Rule 37, as he explained in his Rule 37 testimony, was he divided the jurors into three stacks: the ones that were bad for his case, the ones that were borderline, and the ones that were great for his case. And his goal, aside from getting the ones that were great to the case, his goal was to seat as many jurors that were borderline on being struck by the prosecution because they couldn't consider or were hesitant to consider the death penalty. And that strategy played out, especially with juror Randall Stacy. Yes, Stacy did say that he didn't consider intoxication to less than punishment, but Stacy also said that he was moderately opposed to the death penalty. That's in the juror questionnaires, and he stated that during voir dire. In addition to that, he also stated that he needed to hear all of the evidence before making up his mind about the death penalty. This is the exact type of juror that Gay wanted on his jury, someone who's moderately opposed to the death penalty from the get-go and needs to hear all the evidence before making up his mind. That is trial strategy. And while Fry didn't make the statement of being moderately opposed to the death penalty, Fry also, like Stacy, said that she needed to hear all of the evidence before making up her mind. And counsel also talked about another part of his trial strategy, or voir dire strategy, was he had the entire list of jurors. He knew who was coming up ahead. He knew that if he struck one person, it would maybe bring up other people that he couldn't strike later. And as anybody who's ever tried a case can testify to, and I'm about to quote Mr. Frazier, is you may be forced to take somebody you would prefer not to have to avoid getting somebody you really didn't want. It's clear from the record in deliberating on all the jurors, the ones that were struck and the ones that weren't, that there was a lot of back and forth. There was talk with Mr. Gay about what jurors he wanted, and decisions were made on each of these jurors. But regardless of that, as Chief Justice, as you pointed out, there's just simply no prejudice here because none of the jurors in the mitigation in Form 2 found that he was impaired as a result of intoxication. And Your Honor, that's significant in this case because simply there were no facts that showed that he was intoxicated at the time he committed the murder. And so if the jurors found that he wasn't intoxicated or wasn't impaired by intoxication at the time he committed the murder, then it doesn't matter whether it can lessen the punishment because it's just simply not relevant. Moving on to the second issue, he argues the counsel was ineffective for failing to present evidence of PTSD, alcohol abuse, and childhood sexual abuse. And derivative of that, he claims that counsel was ineffective for failing to consult with experts. The process of mitigation and what counsel's trial strategy was at the time has to be viewed through the lens of what was available at the time. And at the time, yes, Frazier had all of these records. There is a mention of PTSD in the records. What it specifically says is, and it's from a prison record that says nightmares indicative of PTSD. There's not an actual PTSD diagnosis. There's just the suggestion of it. And at the time the counsel is viewing all this and making these decisions, the picture in front of Mark Frazier is this. Randy Gay is refusing to cooperate with any part of the mitigation case. He's refusing to talk to him about the facts of the case. He's refusing to talk to him about his past history. Mark Frazier represented Mr. Gay on the terroristic threatening. So he knows, he's familiar with who Randy Gay is and his past history. He's aware that there was a competency and Act 3 evaluation done years in the past. He knows from that he was found to be competent and culpable, and he didn't lack the capacity. Here, though, the state tried to have subject Gay to an Act 3, and he refused to cooperate. So viewed through that lens, Mark Frazier knows that Gay is not going to cooperate with experts. He's not cooperating with them to develop facts. He's sure not going to cooperate with any additional experts that they try to put him in front of. And he believes, because of his past history with Gay, that there's not a mental health issue or nothing to be found from that. So looking at counsel's actions at the time, it's not unreasonable for him to not pursue any kind of PTSD. Instead, he pursues the mitigation evidence that's readily available to him. And that was actually a very strong mitigation case. It was presenting through the sister about the horrendous childhood abuses that he faced, that his dad beat him as an infant, that it was verbally abusive to him, that he was sexually abused after the father abandoned them at an orphanage. The jury heard the extensive history of what Gay faced. In fact, in the mitigation, on Form 2, the mitigators they actually found, of the 70-something mitigators that were presented, the jury found 48 mitigators, either unanimously or in part. 10 of those mitigators related to his upbringing that they found. In addition to this horrendous childhood, they put on evidence of his excessive drinking. As counsel really summed up in his closing argument, drinking was pervasive throughout the entire case. It was a constant thread throughout the entire case. Virtually all of the mitigation witnesses talked about his drinking. The sister talked about trying to get help for him, and it just simply, he refused help. The other thing that Frazier focused on was explaining to the jury that if you put Randy Gay in prison for the rest of his life, he is not going to be a problem. In fact, that's what he even said was his strategy, was remove him from society and not forfeit his life. He tried to get some testimony out of Gloria, the sister, about this. She testified to the how he had sought out a small engine repair degree in prison and talked to, and that he did some kind of preaching in prison. However, he also put in the PIN pack, the ADC PIN pack. And as a result of doing that, the jury found 9 mitigators relating to prison, either unanimously or in part. And those prison mitigators are laid out in our briefing. The strategy that Rule 37 is saying that Mark Frazier should have pursued is diametrically opposed to the one that was presented at trial. the Rule 37 strategy would have been to put on these experts that he didn't first even talk to until 3 years after the fact, to say that because of this horrendous childhood, that this is who he is, that he's quick to startle, that he's been conditioned to be aggressive and to go off. And when he's under stress, he reacts violently, aggressively, and suddenly. That's the complete opposite of the picture that Mark Frazier was trying to paint. That's put him in prison, you will never hear from him again. It's difficult to imagine a more stressful environment than prison. So putting on the strategy that Rule 37 counsel is arguing for would not only have undermined everything that was accomplished at trial, it would have left the jury with a clear picture of put him in a stressful environment. He is conditioned to act aggressively and lash out. He will do this again. And the only remedy for the jury is to give him the death penalty. So, in short, the Rule 37 strategy would have completely undermined the strategy at trial. The strategy at trial, and would further have given the jury an excuse and a reason, and basically begged the jury to give him the death sentence. So, as a result of that, there's simply no prejudice for failing to pursue the PTSD, the sexual abuse defense, mitigation strategy. Or the alcohol abuse. And on top of all that, he simply cannot show prejudice, because all of these things that the experts would have testified to, all of the facts came out, and they're in the direct appeal record. The only thing that wasn't talked about was that Glenn Gay sexually abused him. But in the record itself at trial, there's discussion of him being sexually abused as a boy. And if you look in the pen pack, it shows that he claims that he was sexually abused in prison. So the sexual abuse is throughout the record.
Mr. Jackson, let me ask you this question. The trial court did not make any specific findings of fact or conclusions of law on Gay's claim that trial counsel failed to investigate and challenge the aggravating factors of the deaths of Glenn Gay and Jim Kelly. And of course, under our Rule 37-5I, does this not require or warrant us to reverse and remand to the court to make those findings?
No, Your Honor, I don't think it does, because it's just plain from the record that the claim was absolutely meritless. There's testimony there about exactly what Frazier did. He obtained the files on these cases. He obtained the Kelly file. He obtained the Glenn Gay file, and he litigated the Ward file himself, so he knows what's there. And the only testimony that he did.
Mr. Jackson, don't we have a heightened standard of review in death cases? I'm kind of tag teaming with Justice Wynn on his question. I mean, don't we have kind of greater protections when we're dealing with death?
Your Honor, I think while the common phrase is yes, death is different, and this court has tended to lean towards a heightened standard of review, it's just plain from the record that the claim is absolutely without merit. And this court can look at the record and adjudicate that.
Well, isn't it up to the circuit court, though, to make the ruling under 37.5I and make those findings of fact and conclusions of law?
Your Honor, I think this court, based on the record that's before it, can make that conclusion. Unless this court has further questions, the state asks that this court affirm the denial of Rule 37 relief. Thank you, Your Honor.
Mr. Jackson, before you go, though, even though I understand your argument that the claims may be meritless, isn't it incumbent upon the trial court to sufficiently state in its order what its findings are?
Your Honor, I think the trial court probably should have made findings. However, it's also incumbent upon appellant if there's not a ruling on it, to bring up a record that shows error. And if there's no ruling, he should have sought that out and got that ruling before coming up to the courts. Again, unless this court has any further questions, the state asks that this court affirm. Thank you.
Okay, rebuttal argument for the appellant.
Just a very brief word back on the reasonable investigation issue. In this case, the specific issue is whether trial counsel made a reasonable decision that made the particular investigation, in this case, into expert testimony that revealed mental health disorders reasonable. The state's response and the trial court's finding was a lack of cooperation. I suggest that the record does not bear that out, that in fact the mitigation trial specialist said, I do not recollect Randy saying not to pursue a specific line of investigation with a specific expert, but there was sort of a general lack of interest. Under the ABA guidelines, Porter versus McCollum, Wiggins versus Smith, trial counsel has a duty to investigate relevant mitigating evidence, no matter what the level of uncooperativeness is on behalf of the defendant. That's the only rebuttal I had. If I can answer any questions, I'm happy to. If not, thank you all so much.
Any questions? I thank you.
Thank you, Judge.
Okay, that'll conclude our oral argument in this case. Let me mention to the justices, I think we've all signed up for the new Zoom government account. And whenever I was doing some test runs on the invitations a day or two ago with my staff, they were having difficulty logging on. So I think we've gotten that resolved. We sent out a second invitation late yesterday afternoon between 5 and 6 o'clock if you'd use that link to attempt to log on. Hopefully everyone can log on for conference on that link. But if you have any difficulty, please bear with me because I'm going to have to get Tim or Derek to assist me to get everybody logged on properly. But I just wanted to mention that in case there was any difficulty. Okay, that concludes our oral argument in this case. And court will be adjourned. Thank you.
Thank you.